Good afternoon. Welcome. I'm Dr. Jill Brooks, Director of Education for First Healthcare Compliance. First Healthcare Compliance is helping healthcare providers and billing services around the country reduce compliance risks by using our cloud-based comprehensive compliance solution. Each month, we provide a free monthly webinar bringing different experts in the field to discuss topics relative to healthcare practices. We are so pleased to have Kimberly Hoffman, Bruce Tigani, James Gallagher from the Morris James Healthcare Industry Team joining us today to discuss taming overhead and compliance. Is practice integration in your future? Morris James Multidisciplinary Healthcare Law Team delivers practical, business-oriented solutions to a large portion of Delaware's healthcare industry. Through their understanding of businesses, industries, and government entities, they help simplify the complexities faced by their healthcare industry clients. Kimberly?
Thank you very much, Dr. Brooks. On behalf of the entire Morris James Healthcare Industry Team, I want to thank First Healthcare Compliance for having us present on the topic of practice integration today. Before we get started with the substance, I want to draw the attention of the audience to our disclaimer. Making changes to one's physician practice is a very important business decision with legal ramifications, and we urge all of you who are listening in undertaking such an endeavor to consult specifically with legal counsel about your particular situation. This presentation today is designed to provide an overview, and at the end, we do provide our contact information, and we would be happy to hear from any of you. But please understand that today's information is an overview only and not to be relied on to make those important changes to your business or to your legal situation that you may be contemplating in the future. Now that we are past that housekeeping matter, I want to introduce my partner, Bruce Tigani. Bruce has been practicing law for over 30 years, and he has a very substantial practice in the area of physician groups in this region. He structures groups that are just starting out. He deals with buy, sell, and asset arrangements. And importantly for our purposes today, he helps his clients keep up with the ever-changing regulatory and compliance environment while they're implementing their business decisions. In addition to representing physician groups, of course, Bruce's practice extends to the business interests and personal planning for individual physicians as well. I also want to introduce my colleague. Well, let's skip me. I'm the least interesting of the three of us. My colleague, Jim Gallagher, has a practice that's very similar to Bruce's. He has become a real expert in the area of Stark and HIPAA, and his clients are also in the area of physicians groups, individual physicians, and he helps them structure their entities, their business arrangements with one another, to document what they want to do going forward, to modify existing arrangements. And importantly, Jim has an LLM in taxation, so all of the important tax considerations that are underlying these decisions, he's very comfortable giving advice in those areas. Now back to me. I'm Kim Hoffman. I'm the head of the firm's multidisciplinary healthcare practice, and I am more on the government relations, regulatory compliance, administrative hearing side of the house. I like Jim and Bruce. I also do real estate transactions and asset purchases. Some of our other partners who are not present with us today handle a range of issues from medical malpractice defense to employment law matters. The three of us are more on the regulatory and compliance side. If you have any questions about those other areas of law, of course, we would be glad to get any of our colleagues involved in helping you with any of those matters or answering your questions. So why is practice integration a hot topic, and what makes it interesting to this audience to talk about it? Well, as most of you have probably noticed, the practice of medicine is getting increasingly complicated. There is increased exposure to liability, both at the federal and state level. There are increasing pushes to change the business model of practicing medicine, to reimburse physicians in different ways, to provide for different forms of peer review. And on the business side, it is getting increasingly difficult to actually bill for services. It requires a billing professional normally who's very highly trained in billing matters. And in addition, it's not just your mother or father's medical practice anymore with regard to patient information. The requirements for privacy and security of patient records, some of which are on the books but are just coming online now, are getting increasingly intensive. And as most of you are probably aware or maybe have already implemented in your practices, electronic health records are are very much being pushed. Maybe your practice has already gone to that. If it's not, there are a lot of incentives in place to make that happen. But of course, once it happens, it has to be maintained properly, and that's yet another expense toward maintaining that information. Now, at the same time, unfortunately, there has been a lot of downward pressure on reimbursement rates. So the cost of covering all of these compliance matters is a lot more difficult to meet because of what's going on with reimbursement rates. And finally, just aside from the practice of medicine, it's getting increasingly expensive to be an employer. From the cost of benefits to implementing the kind of compliance programs, just as an employer, from sexual harassment up and down, to make sure that you're not going to get involved in some kind of litigation, or you're going to stay compliant with other laws that are not healthcare related. That's another area of expensive compliance that it can be difficult to handle in a smaller shop. So practice integration is something that can actually help with that. And Bruce is going to kick us off by giving us an overview of how practice integration can start to address some of those concerns.
Thanks, Kim. As you've alluded to, the practice of medicine these days now almost mandates a proactive approach to strategic planning to take into account all those relevant factors that you just discussed, both on the professional side and on the quote-unquote business side. A properly structured practice integration platform enables physician practices to strategically combine and operate more efficiently in order to meet the demands of the healthcare environment that's out there right now, which has ever increasing regulatory burdens and shrinking reimbursements, as you all know. We tend to call practice integration group practice with benefits. It provides a professional practice structure, be able to implement centralized management to achieve economies of scale where most needed, while allowing sufficient autonomy at the practice or location level to preserve individual professionalism and proper incentives in place. And in addition, it's going to enable the use of expanded in-office ancillary service exceptions to increase both efficiency and profitability while maintaining regulatory compliance. So what we're looking to do is, with this economies of scale, is reduce the administrative burdens on the clinicians and strengthen the administrative knowledge of what will be a dedicated management team through the centralized structure, not a management team that's being called on to do a number of different tasks within each office.
So tell us a little bit about the nuts and bolts of how that works in real life, Bruce.
Well, the initial threshold when it comes to drawing up a practice integration model and implementing it is for the entire arrangement to comply with Stark Law group practice classification. That facilitates the ability to use expanded physician services and in-office ancillary services exceptions that are unique to group practice status under Stark. then you can achieve compliance with various underlying Stark federal anti-kickback and additional federal and state regulatory requirements. In general, the group practice compliance must include more than just kind of an informal affiliation of physicians, just kind of sharing profits. It's got to be more than that. It can't be separate practices under common ownership or control through a physician practice company. It's got to have some substance to it. In fact, a fair amount of substance, but not so much that it steps on the toes of the profession or the autonomy of the individual physicians themselves. One of the ways to do this through the centralized decision making is to have a representative body or board of directors with effective control over the group's assets, liabilities, setting of budgets, compensations, salaries. But again, should be a representative body so that it takes into account not only the locations where the physicians are, but the clinical specialties and subspecialties. And in that way, you can ensure that the voices are heard and that the practice takes the right direction.
So Bruce, I know that we all live and breathe Stark every day, but maybe sometimes we kind of forget the big picture as it relates to Stark. What happens if a physician or group of physicians would try to implement something like this without paying attention to what their Stark requirements are? What are the consequences of running afoul of Stark?
Well, you better not be billing Medicare and Medicaid. That's one of the things, because you will have to reimburse those billings if they did run afoul of Stark. There are penalties in place for doing that. There's self-reporting in place now. There's taking the risk that you will be disqualified from both Medicare and Medicaid qualification and credentialing, which has a long-term effect on practice. So I think all the physicians and administrators out there, Stark is usually a term that's going to draw their attention, and they're aware that they don't want to run afoul of Stark. Jim, do you have any other?
Yeah, you've hit on it, and really the key is, for the practice is the continued ability to be able to use federal payers, and that can be just a crippling blow to lose that. Not that civil monetary penalties being assessed and treble damages beyond that aren't also a difficult pill to swallow. But we've hit on the Stark areas, and that is the initial threshold. And like Bruce said, that's a good eye opener to start with. You need to meet those requirements. Once you've hit those requirements, there are a lot of different variables that can change depending on the parties that are at the table. And the rest of slide 8 shows you kind of the different permutations that can arise. And there is a fair bit of flexibility that can be done while still qualifying under the Stark group practice classification. The first one is, well, what specialties are going to be involved in this new integrated group practice? For it to be single specialty, and we're looking at something that would be traditionally called a horizontal integration, where it's same services, broader scope, more service providers, perhaps more geographical area covered. Absolutely, that's the traditional integration that's considered. A vertical integration, practices that really feed off of one another, also permitted, and also all the more important to keep an eye on the Stark group practice requirements because of the referrals that are going to be going on within the new group practice. We talked about on the previous slide all the benefits that can arise even short of referrals and things like that. So we might have an integration that's really neither vertical nor horizontal, but two practices or more that have pre-existing relationships, that know one another, that have shared culture, and that just see a benefit from shared overhead, shared culture, and think that there would be a lot of benefit to integrating, and that's certainly permissible as well. The offices that are involved, we've noted as well, because one group may be coming to the table and saying, well, look, we already have 2-3 offices. We have physicians that might be splitting time between different office locations. when we come together, are we going to lose all this growth that we've developed over time? Because we'll talk about how much we want to keep decision making to the greatest extent possible at location by location. So there is still some location independence, despite the fact that we need this centralized management structure under Stark. And that's certainly permissible as long as we stay within the bounds of Stark. And we can look at a location, quote unquote location, the same way we looked at a group coming in, even if there are multiple sites involved. The group practice can still look at those multiple sites as one of the locations as far as micro decision making moving forward. So that's certainly going to be permissible as well. And then that bottom entry gets into balancing the centralized management that is absolutely required under Stark, but works in the autonomy that can be realized from a location to location standpoint. Again, all going to be subject to the centralized management obligation. But it all depends on how you tier things, where decisions can be made, because more and more of the decisions can be made at the location standpoint. The group that came in is basically keeping their identity to some degree, and that extends also to keeping their name identity. There's a lot of goodwill in the historical name that they have developed, and that's something that can be maintained by referring to themselves under their old name and referring to themselves as a division of the new centralized group practice.
Well, I think you're getting into an area, Jim, where there's a lot of worry about what practice integration is really going to mean to a physician's group. And that's really a loss of, potential loss of control over how finances work, how the control of the business is operating. So you're going to talk to us a little bit about how much flexibility there is within the Stark safe harbors to still make that, retaining some of that independence possible.
Right, absolutely. And we will get to the strict requirements because they're absolute under the safe harbor. But there is still a lot of flexibility that is maintained under the group practice structure. So, for example, one of the groups coming to the table for a potential integration might say, well, we're a small group, 2 or 3 doctors. We're used to having a hand in all the decisions that are going on. And yeah, I'm spending a lot of my practice handling business decisions. I don't like that, handling administration, regulatory compliance. But, it's also comforting to me to know, when my head hits the pillow at night, that I have a handle on everything that's going on. And one of the ways that can be addressed in practice integration is by having more decisions pass through each location, which could continue to hold meetings, including as many of the physicians at that location as they desire, but they can kind of work hand in glove with the centralized management that is going to be arising. And another way that that's going to happen, I think, is getting to point 2, which is that centralized management. We're going to be drawing the participants from each of the locations. We're going to be drawing them from the specialties that are involved. We want to make the governing board as representative as it possibly can be, so that every physician in the new group practice is going to feel like I have one, if not multiple, people fighting for my particular location. They know what it's like to be in my shoes, handling my particular specialty, and I know that they're going to represent my interests in the centralized management. And of course, the bottom line that we keep selling is that's going to free up time and effort for clinical matters and for other personal matters. And what Bruce has said before is we're in a situation where you can find yourself now running your practice rather than having your practice running you. A related topic is the financial interdependence, and that's going to be an absolute requirement, much like the centralized management. But again, you can have sort of branch accounts that can be managed location to location, and you can have some of the micro purchasing done at a location to location level. And even beyond that is the compensation question, which again, one group coming to the table might have a more egalitarian payment structure. Another group might be doing a lot more eat what you kill. Even though all revenue is coming into the new group practice under its one identification number, there's still an ability to allow each location to dictate how the compensation among its location is going to be handled. We want to vet it through the centralized management. We want to get absolutely their blessing and make sure that they have a handle on what's going on. But all of that can be based on the feedback that is coming from each separate location.
So there are definitely some lines that are going to be placed around autonomy of individual physicians going forward, but doesn't necessarily have to be an absolute dictatorship from the top down throughout the integrated practice. So we're going to move on to some very specific objective requirements that Jim's going to tell us about that Stark imposes, and I mean, these are sort of non-negotiable things that you have to hit to do a successful practice integration under Stark.
Right. It's more fun to talk about the flexibility, and there is a lot of flexibility allowed, but these are the 8 core requirements that OIG is going to look at as to whether there is a problem qualifying under the Stark group practice safe harbor. And it starts with being a single legal entity that is a physician group practice, and that's going to mean one taxpayer identification number. It's going to mean one billing number for federal payers. It's going to mean accounts receivable are all going to be paid to the one entity, the new group practice that results. And point 6 kind of is related to this being a unified business. It should not be an informal affiliation that's formed just to be able to share profits from referrals, because that's the number one thing that OIG is going to be looking at for a potential Stark violation. We don't want separate group practices that just have some common overhead. That's not enough. We need the centralized decision making with a central representative body that has an effective control over the group's assets and liabilities and works on setting up the budgets and the compensation and the salaries, though we talked about how internally you can have a structure that provides for maximum feedback coming from the locations to that centralized body.
And Jim, just one thing there, we realize that it has to be centralized management component, but with the right makeup of a practice integration and a group practice, there should be some deference to the practice locations on what they need in order to thrive as a practice location. So while the centralized management has to approve and verify and make sure it's compliant, I think in many cases in practice, again, if you have the right group together, that the recommendations that come from the locations, even though they can't formally pass it and be completely autonomous on those, they have to go up to the centralized management. I think there is again some deference to what the local practice, what the local clinicians need in order to be successful.
Usually that's what everyone is going to consider coming to the table, because they realize they're coming in to benefit from all the points we set out before, and everyone is going to be agreeable to that idea. And then the more representative a centralized board you have, the more everybody feels like, well, I have a strong advocate. I have someone who understands how our location works, how our specialty works. And I know that if someone is led astray in the centralized management group, I know they're going to rein everybody in and make sure our case is made to the utmost. From a clinical standpoint, there's a bunch of requirements on there as well, a lot of them dealing with physician members. And that's going to be the owners, but it's also going to involve physician employees, employees who stand in the shoes of owner or employee physicians. It's going to be just about everybody short of independent contractors. So you need to have at least 2 of them in your group practice. They need to be furnishing substantially the full range of their patient care services through the group's shared space and shared equipment and shared personnel and staff. And substantially all of the patient care services of all of those physician members are going to be furnished through the group and billed under the group's, like we said, single billing number, with the collections coming to the group's single name and single taxpayer identification number. So you can see what's going on here with the requirements is that the concern is going to be loose affiliations, maybe people having partial services done through this group practice so that referrals can be done by the participating physicians, maybe in a manner that's outside the group practice. That's exactly the type of thing that the Congress was looking to shut down here, and that these regulations are looking to shut down. And again, it's all going to piggyback on points 1 and 6, having that centralized management, shared risk, shared reward.
So, Jim, what you've just taken us through are the stark safe harbor requirements for physician-provided clinical services. These are the things that you absolutely have to hit to do this from that perspective. So, Bruce, I'm going to turn this over to you to talk about the stark safe harbor for in-office ancillary services, which are a little bit different.
Yeah, and this particular area itself is could be the topic of probably a half-day seminar just alone. And this is where I think a lot of the practice integration models can either kind of fail in a practical matter or be very successful in a practical matter, depending on how these are structured. As far as the requirements for in-office ancillary, as I'm sure you all know, that's again even a heightened scrutiny under Stark in and of itself. But it starts with the group practice requirements we just went over, but they want to add the additional safeguard that where the in-office ancillary services are performed vis-a-vis the practice and the physicians themselves, take care that the safeguards are in place so that somebody isn't circumventing the system. So we have, two basic types of exceptions that will allow you as a group practice to share in-office ancillary services. The first is that they take place in the same building in which the referring physician or one of his or her physician members satisfies the certain criteria. So if anyone in the practice, and Jim, I think you talked about what physician members are. It's basically practitioners that aren't independent contractors. Refer, and it's in the same building as that referring physician or one of the other group practice physicians, then that will satisfy the same building criteria for in-office ancillary exception to Stark and being able to share. So that's a good thing. The other main exception is the centralized building used by the group practice for the provision of the services. So as you're aware, there's many practices out there that have a centralized building for, let's say, imaging, X-ray, MRI, those types of things. And as long as it's done in a centralized building that's used by the group practice, and there are standards, again, that would be the subject of a seminar that would go kind of deeper into this particular exception allowance, that they can use a centralized building without having to have it be in the same building of the referring physicians, and it still qualifies again for in-office ancillary services, meaning that it can then be shared within the group, even if you're the referring physician and not the physician that is personally performing those services.
So next, Bruce, I think you're going to talk about how physicians can maintain as much autonomy as possible while they're still complying with all of these different safe harbor requirements. But that gets pretty granular about how one runs the decision making within the practice.
Yeah, and we're going to go to a slide after this that's going to give more of concrete examples, but let's talk about some of the concepts first. Um, I think you've heard a couple of times they satisfy the group practice safe harbor. There has to be centralized management beyond the day-to-day operations, although there are certain permitted decision making that's allowable to local management level, including compensation. But that centralized management should be accomplished by a board of directors or a board of managers, executive committee, again, depending on what your structure is, corporation, LLC, LLP. Now, to preserve overall accountability of that centralized management, and Jim talked about this earlier, it is recommended that that board, and we'll call it a board to cover all those bodies that we just talked about, it is recommended that the board be representative of the locations and the clinical specialties or subspecialties so that they have regular monthly meetings guided by their chair and the president and assisted by committees when that's indicated. And that, along with the systematic rotation of management positions, uh, enhances both representative management and an opportunity for all the owner positions to serve in those positions and to consider it more representative again of their individual clinical location interests, and that's key. But centralized management doesn't preclude the ability for certain decision making to occur at the location level. And this is kind of the mix of where centralized management and location level management come together in order to achieve an optimum result, and still be able to get both economies of scale and physicians being physicians, which is what they do best. So you can have location-based compensation arrangements and formulas for the physicians. Again, they have to be subject to centralized board approval or oversight. And we talked about that when it comes to location recommendations to the centralized management committee, that if they're structured properly and are compliant and the location is making the pitch that that's what they need at their location in order to be successful, those recommendations should generally be accepted by the board. Again, providing overall compliance and providing continuity with what the practice in general, the entire group practice is looking to accomplish.
Now, we're Delaware lawyers, and so we are very familiar with Delaware corporate law and give a lot of advice on complying with Delaware corporate law. But some who haven't utilized a formal board of directors structure, might have some anxiety about complying with corporate formalities. So when someone expresses that to you, how do you respond? Do you look at alternative entity structures, or do you just basically kind of give people the 1, 2, 3 on how to do the corporate formalities?
Well, it depends, because sometimes the entity structure that you're going to pick for a practice integration for the group practice is going to be dependent upon what the component practices already are. Because for certain tax purposes, component practices are largely C corporations. There could be a significant tax effect of converting into an LLC or an LLP format, or even an S corporation format. So first and foremost, you got to look at what the tax effect is going to be. Yes, there's less formalities by law that have to be adhered to in non-corporate entities. However, as far as qualifying as a start group practice, those are formalities you're going to have to comply with anyway. So whether it's a board of directors, board of managers, an executive committee, you're going to have the same type of meetings and the same type of centralized management structure, no matter what you are. It's not anything to be concerned about. It's just a good management approach.
But still making sure that one understands what those formalities are and the records that need to be kept and the minutes and the notifications and
Yes.
all of those good things.
Yes.
So where healthcare and corporate law sort of veer into each other.
Yes, and I agree. But I think a lot of those are going to be common sense when you're talking about a service-oriented corporate structure where the members are very interested in what's going on, even if they're not sitting at the table for every meeting.
Right. That makes perfect sense. So I love the next part of this because I feel like this is where we dive into how things work on the ground and how things are going to really work in people's day-to-day practice. And what we've been talking about up to now is law and some theory and an overview of why this is advantageous. But I think the question a lot of people have is, putting the theory aside, how is this going to change my day-to-day in the way that I'm running the practice? And this is what I think that you've attempted to answer here.
Yeah, this is showing a perspective arrangement for a practice integration model and allocating authority, responsibility, decision making between the group practice level, which is your centralized management, and the medical practice location, which is your local decision making that's permitted. And you'll see, and I'm going to let Jim go through most of these, but you'll see some, when you look horizontally, you'll see some only have entries in one side of the table, and others have entries on both sides of the table. And that's, again, the blending of what you can do as far as decision making and authority and responsibility while still being compliant with the group practice requirements of Stark. And again, this is for illustration only. We've tried to kind of isolate certain concepts that we want to bring to light here. So rarely is your practice going to be this simple, but again, this is the structure that you would look at as one example of how it could be put together. Jim, why don't you go over a couple of the
Yeah, and again, it's a template, and many, not all, many of the items should be looked at as if they're almost on a slider, and we're determining how much should be determined at the group practice level and where do we want to leave some independence at the medical practice location itself. Not all of them, because we want to meet our centralized management obligation. But I like how this spells out, you see payroll administration, you see pension, retirement, health benefit plans, information technology. We keep talking about, well, a physician who's going to come into this larger practice and might feel like, well, I'm not on top of my practice and every aspect of it like I used to. Hopefully, when you look at items like that, you might say to yourself, geez, if there's a change in withholding, maybe I just want to trust the payroll staff to know that, and the board of directors or the executive committee to oversee that, or a specific committee of the board. And I don't have to be bothered with that. I don't want to be bothered with ERISA changes that are going to cause a major overhaul to a 401k plan. I'd rather spend time on my practice knowing that I have representative people at the centralized board or on the executive committee who are going to be well positioned to be able to competent to handle these decisions. And I know they're going to take care of what needs to be done at the employer level, and I can spend more time on my practice.
And underneath them, they have a dedicated staff, kind of a management staff, who, again, this is what they do day in and day out. So it's both the kind of the management at the practitioner level, as well as a good executive director managing the business end and keeping the physicians apprised of what's going on there, but with a staff that will run pretty much like any business would run because it needs to.
Right. Then there's some other items where they're in both the left column and the right column, and those are more the slider items. How much do you want to be decided centrally? How much independence should a location have? And they're kind of bifurcated. There's some where you really see where the economies of scale are going to be such a large benefit, as far as negotiations for professional liability insurance, as far as negotiations for major contracts or needs for equipment. If you need a copier, well, now you no longer need 3 copiers because there's 5 locations that need 3 copiers. And from that economies of scale, everyone's going to get a better rate out of it. And of course, professional liability insurance, you just have that heightened leverage in being able to negotiate rates. Now you look at the professional liability insurance and the lending. Again, the party to all of these transactions has to be the group practice. But through internal accounting, there are ways in which you can have any resultant costs be allocated through to particular locations or particular physicians. And so, the benefits are going to be shared by everybody, and particular costs that arise that are directly allocable to a location or a professional, we want to get them in the appropriate box and get them allocated properly such that the costs are not shared necessarily. The benefits are shared and the costs are allocated to where they should go appropriately.
So I would imagine that in the step one, well, I don't imagine, I know. So the step one of this is really sort of a listening exercise to figure out where the physicians and the group is comfortable going with some of these different things. Because when people are coming to us, they sort of already have their ideas of how this is working. And then the question is, as you said, Jim, what do you want to slide over into what category? And it just depends on preference, but that's where this becomes a really customized exercise in putting one of these integrations together.
Right. And employment terms is a good one to hit on as well, because it's a good commingling of the two concepts. Hiring and firing is at the group practice level. It's the group practice that is the ultimate employer. You figure they want to make sure that the appropriate non-compete or liquidated damages language is in there. As far as compensation, we want to make sure we're complying with all the appropriate regulations, but we talked about how some independence can be had at the location standpoint. We keep talking about that. We want to have it identified, we want to have it put in writing, and we want these alternate compensation structures set in advance in writing. But once that is done at the branch, that's passed up to the group practice, and now the branch can decide things like on-call coverage and privileges and working with staff, things like that.
And one thing I just want to emphasize there too is the best practice prerequisites, which I think is a big advantage in a group practice, and that's one of the things that at the group practice level that you're going to ensure when the locations are recommending additional physicians is that they have the right credentialing, board certification, board eligibility, and whereas the location may be blinded by maybe something that's attracting them to that particular physician, at the group practice level, they should be a little more objective as far as whether a particular physician or a particular new group fits into the overall concept of the group practice.
So we've been through a lot of very granular things with how to make this successful, how to make an integration compliant with Stark. But there are some other sort of big picture issues involved in integration that I think we have just enough time for you to give us a little taste.
Well, and we've hit on some of them because they're not totally in the background. And Bruce talked about how the type of entities coming to the table, how that is going to affect what type of entity we're going to want for the group practice. In part because it could have major tax implications. You could cause recognition events that causes tax liability to emerge. In part because, as we were talking about before, they're coming in with some familiarity and hopefully comfort with a particular type of entity and might make them favor using a similar entity moving forward. Culture, of course, we've been talking about it at all turns, and it's important to have that shared culture and everyone on the same page moving forward.
And just to touch on that, I think no matter how big your practice integration platform gets, I think that's something to try to ensure that you have a kind of a consistent culture, at least on what you feel are your value items for the practice, so that decisions that are made will not be outside of that culture box, and everybody will be comfortable from a basic standards and again a best practices type approach.
antitrust is, for small practices, not an issue when there is at least one large practice involved, unless there are many, many, many small practices involved. But it's something to definitely keep an eye on as to what the existing market share is in a particular specialty and how it is going to be affected by the integration. And there's no shortage of laws in place: the Sherman Act, the Clayton Act, the Federal Trade Commission Act. And again, that's a webinar unto itself, and probably an all-day one. The bottom line way to fight it is to make sure you have your argument set as to why there are going to be benefits to consumers from a particular integration. Increased scope of services, increased standards. If smaller groups are going to step up and reach the clinical standards of a larger group that has really made a name for itself in the area. Shared expenses means that there's going to be reduced costs involved, such that there isn't a need to have necessarily higher reimbursement rates coming in. And those are important things to be able to make a case for if you think antitrust is going to be a concern in the integration. And
don't completely take out all of your competition.
Exactly. That is going to be a red flag right off the bat.
I want to move on to this subject of the large and the small practices, but I do have a question that I think is especially applicable in parts of the country like the East Coast, where we're all kind of compressed. There's a lot of state lines, like right 5 minutes from where we're sitting, for example. So does any of this change when you're talking about groups that are trying to combine across jurisdictions versus within one state?
Well, licensing is going to be a trick, and then the type of entity, professional associations, can also be a trick. You want to make sure that the entity, when it's being recognized in a jurisdiction, it's going to be permissible for that entity to be owned by practitioners who are licensed in different jurisdictions, because it's not always the case.
And we're actually looking to streamline that portion of our law in Delaware dealing with professional service corporations to enable that, where most of our surrounding states already have that ability. Right now, ours is a little antiquated in that regard.
But most of what we're talking about here, though, is federal law. So as long as, for example, we were working with, local counsel on local licensing issues, coordinating a practice integration across multiple state lines it's the same exercise as far as what we're talking about here, regardless, because we're really talking about federal law.
Yeah, I think that's primarily the case. Stark and AKS and the ones we're talking about that are you have to touch the bases on are all federal implications.
So tell us briefly, because we're hitting the end of our time, about different partners and considerations in integration.
We've on slide 15 we've thrown out 3 different types of scenarios, and I think you can go back to the prior slide on 13. And as Jim said, you can slide things, certain of those decision makings back and forth. Again, subject to certain parameters. They do have to be Stark compliant, so it's not an unlimited slide by any means. But I think you get large practice with large practice. I think it goes right back to what we just talked about with antitrust. You've got some issues that you have to address. So what you're bringing to the table as far as the hospitals in town, the payors and the public, you better be able to make a pretty good case for the fact that you're largely eliminating competition. Sometimes this can be aided by the fact that other larger groups from other states, surrounding states, have made inroads already into that particular state, so that even though it looks like you're eliminating a great deal of competition, there's actually larger animals out there that are looking to become predators to even your practice. So again, a case by case scenario, and antitrust is probably one of the more facts and circumstances cases that you have to address.
And
So
culture is going to be a big aspect of the large, integrating with large as well. I don't know if it's a bigger issue than antitrust, because antitrust can be certainly a concern. But you have very well ensconced cultures when you're dealing with these types of large practices, and a lot of times when it comes time to sit down at the table and figure out how an integration is going to work, there can be a lot of butting heads and loggerheads arising from that. So that's going to be a big concern, more so for the large practice integrating with a large practice, I would say.
And I think that follows with the second bullet point. If anytime you have kind of the small practice integrating with a small practice, it's can be a lot of the same issues on this is how we've done it. I think the third bullet point in large practice integrating with a smaller practice, I think the smaller practice has already decided they like the platform of the larger practice, and actually would like to adopt those practices. So you have less kind of it may be more culture shock, but it's less of kind of saying I want to still do it my way.
You tend to see they're looking for a soft landing place, exactly, and then the hospital might not be ideal. And so being able to merge with a large practice, again, there might be a transition, there might be concern with getting standards up to par. But usually by doing it this way and by doing it through practice integration rather than a straight merger, the name recognition remains. And now they're in a position where they have their existing name and they still benefit from that for referrals locally. And now they're part of the larger practice, which might help them in succession and bringing in younger physicians moving forward.
So as excited as we get about advising on and implementing this process, I am going to have to wrap it up for us. So to sum things up, we trade off some autonomy in a practice integration, but the advantages are spreading out the cost of compliance and being able to do referrals among groups of physicians that would otherwise not be permissible under Stark. And it's just important to understand what the ins and outs are going to be, and if you're going to do it right and understand what's involved in advance. So if there are any of these issues that anyone would like to do a deeper dive on, I provided our contact information. We are going to be doing a couple more of these seminars that actually do a deeper dive. And again, I want to thank Jill and her team for having us today. It's been a real privilege to speak to you all. And we hope to hear from you with your questions and the things that we didn't think of. You can tell we really enjoy talking about this. Thanks very much. Bye.
Well, thank you, Kim, Bruce, Jim. There's a really great presentation. If you have any questions for them, please use their contact information on the screen. Please join us again on December 16th for our next free monthly webinar, Medical Decision Making and the Medical Necessity Link, with Lori Desjardins, the Director of Consulting for Coding Strategies. You can register for this webinar at our website, 1sthcc.com, or on the Paycom website, paycom.com. Our team at First Healthcare Compliance is available to you 9 a.m. to 8 p.m. Eastern Standard Time. Please call or email us if you have questions or would like to schedule a quick demo of our software. Thank you and have a great day.